Is it time to recognize what I'll call semi-cohabitation as a basis for at least reducing the alimony award in certain cases? Utah law allows for modification of alimony by either reducing or terminating it. There are various reasons why one can obtain a reduction in the alimony payment obligation. But in most cases, alimony reductions are ordered when the payor's ability to pay has decreased due to no fault of his or her own, or where the payee's need has decreased, or a combination of the two. Decreased ability to pay is typically proven by the loss of or change in employment or disability on the part of the payor. Decreased need is typically shown by proving that the payee's income has increased and or that the payee's living expenses have decreased. While decreased ability to pay and or decreased need could be so great as to warrant the total termination of alimony, most petitions to terminate alimony are based upon claims of cohabitation on the part of the alimony payee. Cohabitation means living in a marriage-like relationship even though one is not. Proving cohabitation, however, in this context is extremely difficult. In fairness to the courts, it is difficult to determine what marital cohabitation is, as every married couple does not live and reside together in the same way. Yet it seems that both the district and appellate courts in the state of Utah often selectively place more or less emphasis on the various factors to be considered on a petition to terminate alimony based on cohabitation to reach the outcome they desire. This is especially true when an alimony payor can prove that the alimony payee is spending a substantial amount of time overnight at the residence of a boyfriend or girlfriend, what we in the legal profession call a paramour sometimes, when we want to look for a gender-neutral term. As the overwhelming majority of alimony recipients are women, however, I will refer to an alimony recipient in the singular form from here on out as her and she. Now, most alimony recipients aren't dumb. They know that if they cohabit, their alimony can be terminated. And so many alimony recipients who want to cohabit and still receive alimony will game the system so that technically they do not qualify or appear to qualify as cohabiting, even though most people would see it as a clear case of having their cake and eating it too. As you might imagine, it is difficult to determine the exact number of overnights and shared expenses and experience that pass the terminate alimony test. If you could try a close case before several different judges, you could easily get different outcomes. One judge could find the number of overnights, meals, and expenses shared together, etc., meeting the cohabitation standard. Another judge could find that cohabitation missed the mark by just a day or meal or dollar or two. When rules for terminating alimony come down to splitting hairs this finely, injustice occurs on both sides of the alimony issue, though usually it's the alimony payor who suffers injustice more often. After all, if an alimony recipient is spending half or more of her time at her paramour's home, eating his food and benefiting from his expenditure of money on her for entertainment and other activities, the alimony recipient's financial need is clearly reduced by those financial benefits that the paramour confers. Alimony is based upon meeting a woman's financial needs without contribution from anyone else. It is thus manifestly unfair for such a woman, or a man, but you understand what I'm talking about here, to continue to receive the full alimony payment each month if, post-divorce, she regularly receives from her paramour the benefits of him paying for half or all of some of her lodging, utilities, meals, other necessities, and entertainment expenses, yet continues to receive alimony that was calculated and awarded to cover those costs without contribution from anyone else. That's double dipping. Now, while I believe in marriage and I oppose shacking up, I am no prude. I recognize and respect the fact that adults are free to cohabit if they wish. Alimony, however, was never meant to be paid to one who does not need all of it. Having a boyfriend pick up the tab for the occasional meal is clearly not a sufficient reason to reduce alimony and claim cohabitation. Receiving a gift of a bracelet or flowers from a generous boyfriend would not be sufficient either. Spending the night at a boyfriend's home infrequently would not be reason to terminate alimony as well. Even going on a vacation with a boyfriend for a week or 2 or 3 or even 4 in the span of a year or more would not be enough to spend time together justifying terminating alimony. But if a woman is spending the night with her boyfriend on an average of half the time, yearly or monthly, and if she and her boyfriend are routinely sharing the costs of food and lodging and other activities and expenses, then while that may not be grounds for terminating alimony and while that may not constitute cohabitation as we currently define it, it would certainly be grounds for reducing alimony commensurate with the financial benefits that this, for lack of a better word, semi-cohabitation confers. What if we created another standard for reducing alimony as opposed to outright terminating it altogether? One that was not as strict as the standard for terminating alimony. Such a standard would have many beneficial effects. 1, it would help to keep alimony recipients honest, knowing that if they get too cute and dance too recklessly close to the line, they could see their alimony decreased or perhaps even eliminated. That may lead many to take a more conservative approach to their post-divorce romantic exploits. It might lead them to conclude that it's more honest and less work to admit, all right, I'm cohabiting, so you might as well stop paying me alimony, than it is to maintain the level of deception and work needed to remain qualified to continue receiving alimony illicitly.